Good morning, everyone. This is Wednesday morning for the Minerals Business and Economic Development Committee meeting. This is going to be our last meeting of the session for bills. We will have one more meeting on March 4th to discuss interim topics. That will be a joint committee meeting with the Senate at that time. So we will call the roll. Mark, would you do that for us, please?
Representative Campbell.
Here.
Representative Knapp.
Here.
Representative Larson.
Here.
Representative Lawley.
Here.
Representative Riggins.
Excused.
Representative Schmidt.
Here.
Representative Tarver.
Here.
Representative Weber.
Here.
Chairman Heiner.
Here. Thank you, Mark. Some members have other bills that they're presenting in other committees and will be in and out during this period of time. So be sure and leave a absentee vote and good luck with your bills.
Thank you.
Chairman. We're honored to have a dignitary here this morning with us, front and center, one of our esteemed colleagues in the Senate. Senator Rothfuss, would you introduce yourself and tell us what kind of information and knowledge you're going to share with us?
Thank you, Mr. Chairman. Senator Rothfuss. I am also a member of the Senate Minerals Committee, as you all know, and today I'm bringing Senate File 65, which is Data Privacy Government Entities, and this is the product of work over the last 2 years on the Blockchain Select Committee. We worked on it a couple of years ago and didn't get a bill to where we thought it was ready for prime time, and so we worked on it, completed it this last year, and this is the product of that work. Mr. Chairman, privacy is inconvenient for government, so it takes a little bit of work to get to the point where you're threading the needle appropriately and government can still do its work, but we can respect the privacy of the people. This legislation is drafted in a way that it doesn't call out a lot of explicit exceptions, and we might find interest groups that always want the carve out of an explicit exception, but we work very hard to address all of the concerns that we heard and that we could anticipate so that there's always an exception pathway available. We don't get anyone wrapped around the axle, but what it tends to come down to, you'll see as we walk through this bill, is that if it's a reasonable exception, there's going to be a path to it, but we're not just trying to carve things out because it's easier to avoid privacy than to protect privacy, and you'll see that as we walk through it. There's effectively two functions here. One is getting to the idea of not buying and selling and transferring data by the government, and the other is getting to an idea of an individual's right to access and remedy that data. So we'll see that as we walk through. Bill starts on page 2 with a series of definitions. The first is de-identified data. This is getting to an idea where the data cannot be linked to a natural person or personal digital identity. Government entity, this legislation is going to apply through government entity definition to basically all political subdivisions, agencies, and instrumentalities of the state, but it does not include the judicial branch or law enforcement. We'll have a definition of law enforcement. They are already pretty darn well governed by what they can and can't do with data, how long they retain it. So we just decided we don't need to touch that. That's too heavy at this point in time and avoided it. Identified or identifiable natural person, that's an individual that can be identified or directly linked through the data. Page 3, law enforcement agency. Regrettably, there's no perfect definition of law enforcement agency in statute. This came as quite a surprise to us, so we had to create our own. Couldn't believe that was the case. And we have a definition there then that is appropriately inclusive of the agencies we wanted to consider.
It's just like we have.
Personal data is data that's reasonably linkable to an identified or identifiable natural person and does not include de-identified data. And then we refer to a previous definition of personal digital identity in statute. Mr. Chairman, committee, the first provision of the legislation is 921-202, which is limitations on personal data by government entities. And this actually came out of some interest from the northeastern part of the state where some constituents found out that the government, a county, no, it was a state agency, purchased a large data set of information about citizens of the state of Wyoming, effectively for marketing purposes. The concern that came out of that was this then becomes, is it a public record? How long do they keep this data? Why do they have this data? And why do we justify the state of Wyoming purchasing data about citizens of the state of Wyoming? I do a little bit of a kerfuffle, an appropriate one, and we worked on trying to indicate policy of the state, which is that no government entities shall purchase, sell, trade, or transfer personal data without the express written consent of the natural person, except as otherwise expressly provided by law. That's the key provision, and then we've got some exception language. Exception Romanet 1, government entity may transfer personal data to another government entity that complies with this. Makes sense. 2, a government entity may transfer personal data to non-governmental entity contracted by the government entity to provide or assist with government services, assuming that they contract to agree to uphold these provisions. In other words, they also have to protect it. This is an important provision because, as we know, a lot of our agencies outsource a lot of the work. They have to be able to transfer data to engage in whatever that workflow is, but basically ensuring that it's protected. On page 5, Romanet 3, this is the provision that provides an exception under every circumstance. So if somebody comes along and says, oh, this will break things, no, there's always going to be a path, and it's this and another provision a little bit later. Romanet 3, a government entity may petition the elected governing person or body with direct authority over the government entity for an exception to this subsection, basically any type of exception. And that governing body can provide any type of exception publicly in writing that applies for up to 2 years. So there is no limit to this authority as long as you have an elected body or official that is responsible, that is willing to sign off and say there is a public interest in us doing this. Here is that public interest. Here is a document that indicates it. So it holds responsibility to electeds to make a decision as to whether or not there is a specific interest. And then the beauty of it being public is we can take a look at that. And the public can take a look at that. We can consider it. Does there need to be an exception? So this was an important provision to ensure that we weren't wrapping ourselves around the axle and creating a problem that needed to overcome this statute and therefore would hold back a public interest. And then you see Romanet 4, this is the only specific carve out relates to HIPAA and FERPA. These are federal acts where if compliant with the HIPAA and FERPA policies, then it would allow for transfers that are explicitly authorized. B provision, you see, any Wyoming resident may request a copy of their personal data. Government may charge consistent with Wyoming Public Records Act, and that's language which indicates if it's a large task, you can charge a modest amount of money. The C paragraph on page 6 indicates that a Wyoming resident who objects to the accuracy, completeness, pertinence, anything else related to it may provide that objection. The government entity maintaining the personal data within 60 days of receipt shall, Romanet 1, investigate the validity of the objection. 2, if they deem it meritorious, provide for a remedy. 3, if they find that it lacks merit, provide a statement to the individual or allow them to provide a statement of objection. And then Romanet 4, notify the resident in writing of their decision. And this is another provision here that we see on page 7 that is very important. If we have any concerns specifically, they come along the lines of public records and other areas. This D provision is strong and governs. It says, to the extent that a provision of this article conflicts with another provision of state or federal law, the other provision shall control. In other words, if this conflicts with any other legal right to buy, sell, transfer, trade, whatever else that's out there, so we have a statute that says you can do it, you can still do it. And that gets to a public records concern where a lot of people are saying, well, we use this data. Okay, it's under the Public Records Act. That's how you're getting the data. You have access to it. The D provision here makes it very clear. So we had a lot of objections from different entities, agencies that had concerns. They all get remedied by this D provision that we've heard so far, or we had some other provisions put in, and then there is the potential for the exception request. So just to be clear, even though we're not explicitly calling out or carving out exceptions, If they have statutory authority to do something, this does not block statutory authority, whether it's state or federal. Bottom of page 7, 921-203. This gets to personal data collection and retention. This is agencies, as well as all subdivisions of the state, have to have, as you see in the A paragraph, policies such that each government entity that collects or retains personal data shall adopt, enforce, and maintain a policy regarding that collection and access. On page 8, no government entity, this is the B paragraph, shall collect or maintain more personal data than is reasonably necessary for the performance of the government entity's lawful functions, and they shall identify a specific predefined purpose for that collection. This is the over-collection concept. A lot of our government entities over-collect because it's handy. That's the justification. It's nice for us to know. We may need the information later. Well, if you don't have a specific reason, don't collect the data. It's bad for the public. Over-collections lead to data breaches and lead to disclosures and lead to liability. I see.
Vice Chair Tarver, a question.
Mr. Chairman, thank you. So this being said, does the people that are having the data collected on them, do they have to give permission for this, or how does that work currently?
Senator?
Currently, there is no reason to have any sort of permissions, no reason to necessarily have any sort of policy. So the government is going to collect data on you and you basically don't have a say in it. It is a challenge to actually tell the government you can't collect data. So what we're doing here is saying you have to have a reason to collect the data and you have to have a written policy basically on why you're collecting specific data. And then you'll see in the further provisions some additional details to that data collection.
Follow-up? Representative Lawler, please.
Thank you, Mr. Chairman. Good morning, Senator Roth. It's always good to see you. Thank you for being here. Help me understand, I know why you're doing what you're doing. I understand that, but with this provision on page 7, under the Public Records Act, tell me how that's not effectively just driving a big truck through the middle of what you're trying to accomplish in the bill. Kind of help me understand that, how that might, if someone used the Public Records Act. Is there still some things they can and can't get from the Public Records Act? Help me understand how this doesn't kind of make this huge loophole.
Senator?
Mr. Chairman, Representative Lawley, we don't change the Public Records Act at all. So there are explicit things that you can get from the Public Records Act. And the default is if the public's holding it, you can get it. And then there's the exception language. There's 2 different exception language, like major paragraphs, and then a lot of Romanettes underneath each of those that provide for specific exceptions. So this doesn't change any of that. We're not changing what is and isn't a public record. But from the public record standpoint, if I over-collect data on you, I don't necessarily have a public exception or a public records exception. So it might be a public record that I've over-collected on you because I'm holding it and I'm a public entity. So this B paragraph basically says, whoa, if you don't have a reason to collect it, let's not collect it. Let's not make an additional public record that doesn't need to be there, because it isn't the responsibility of the government just to know everything you're doing. There are only certain circumstances when they should know, and different agencies have different obligations.
Follow-up?
Can you walk me through the remedies? So if this is violated, if there is, for example, overcollection and it's been able to prove, walk me through what happens, or even any other violations of the act, this act specifically. So,
Senator Rothfuss.
Mr. Chairman, we don't have, and it was intentional, a lot of teeth on this at this point in time. We really basically just wanted a set of policies, and you'll see we've got some other provisions there for what the obligations of the agencies are, with the expectation that they will start to follow those policies, put together policies on data collection, and that by and large, it's going to lead to a more appropriate data retention and collection process. We've had a lot of discussions. We've seen a lot of legislation that provides penalties, but it's penalties against the government. The idea that you're able to sue the government for a civil action or something like that just means that taxpayer dollars need to go to a specific individual because you have an agency screwing things up. So at this point in time, our choice was just put in place policies that, assuming you get a 99% or a 95% follow rate from agencies and from the governments, that you end up with a better system for the people. And that's our expectation. It's not to be punitive, it's to try to establish a government system that appropriately respects individual privacy as its default.
Follow-up?
I appreciate that very much, and we probably have a little bit different views about remedies and against the government, and the reason there needs to be some teeth, and so we'll just set that aside for a moment, but that is a concern I have with the bill, is that it's all great in theory, but if we ultimately can't really do anything, if the government overcollects our data, doesn't follow this statute, it seems a little weak in that regard. So I guess I'm trying to think through with me, are there some other approaches we can take, maybe outside this bill with your concerns about remedies, that would begin to address the issue of data and of how we as citizens have something to hold on to when these things are violated? Because that's really my concern, and it's come up with one of my bills, age verification, and we took kind of the Attorney General out of it in part for that, because that's been an issue in the Supreme Court, the fact of how they don't necessarily take care of their data well in the state of Texas in that case, but and that the harm that would cause and potentially violate people's rights under an age verification situation. So I've kind of looked into this area because of that. Bill, and which makes me like your bill, but the lack of enforcement is troublesome for me. So I just would say that and see if what are your thoughts on that? What is there can we do it somewhere else, possibly in another bill, next session or something? Because I mean, I agree with what you're trying to do, but it could become meaningless.
Senator?
Mr. Chairman, Representative, no, I appreciate that concern, and what it came down to for us is a recognition that we've got nothing on the books right now. There's not even an obligation to try and protect policy. So step one, provide an obligation to try and protect policy. And then as we see a lot of times, you then have the opportunity, we have the opportunity to react and see, all right, is this working and where is it not working? So after I think it's been online for a little while, then I do think it's appropriate to start looking at remedies. And obviously, we're not denying anyone access to the courts. There are remedies. You could file an action. You could say they're not following this law, and a court could come in and say, okay, you have to follow the law. But you're right. There's no substantial teeth in it. But again, I don't see that as a bug. I see that as a feature at this point in time, really, because this is an entirely new system, untried, untested. No state has anything quite this comprehensive. We've got a couple of states that have more modest policies that we read through and took the best pieces of. But this is sort of that trailblazing A game and providing punitive punishments at this point in time. We just thought it was a little early, and you'll see that in the end that we phase in over time obligations for cities, towns, and counties, and then things like special districts, et cetera, have an extra year. So we're just trying to ease this on, because it's not a light burden, but it's an important one.
Representative Lawley has another follow-up.
Thank you, Mr. Chairman. One of the things I'm thinking about is possibly amending the bill to provide for at least declaratory and injunctive relief. No, I understand, again, we have a little bit difference on the issue of damages and things, but maybe a big difference. But that really is a tool that could be put in here that at least gets it to a court, and a court determine whether this law is being followed or not. And if it isn't, providing some declaratory relief, do it, injunctive relief, stop doing it. So how would you feel about that?
Senator?
Mr. Chairman, I don't know that it would be welcome, but it wouldn't necessarily be deal-breaking by any stretch of the imagination. The concern I have is we worked on it, and we also have been working on legislation related to the private consumer sector. So this is much harder, and that's why we don't have legislation in this section when you start dealing with companies instead of. So as we would work on the protection, access to courts, appropriate remedies side of it, as we were doing it in the way we thought was right, I'll say, right, a good legislation, that was like 5 to 7 pages of good remedy. And we were still never particularly comfortable with remedies. So something as simple as you have access to the courts and you can get declaratory and injunctive relief, if it's just a paragraph that says that, okay, you know, that's reasonable and doesn't necessarily burden the state. But I'll just say it became complicated. And again, to the extent that we haven't seen it in action yet, I just don't want to be, I don't want to be too, we've got a heavy stick about this before we've ever seen any state implement a program like this, because we could have gotten something wrong. And it needs to be okay that we screwed up if we're trailblazing, right? That's one of the, Blockchain Select Committee does a lot of that, right? Invent new statute, create it whole cloth. But we're pretty cautious about making sure that we don't break the state as a result of the decisions we make. And so that would be the kind of thing that 2 years from now, once we've seen this running, would be, all right, now let's work on the enforcement provision. That would be my inclination. I'm very patient with these bills. We operate them for several years. We've been talking about this one for at least 3 years, and this is the first year we brought it. So that's my thought.
Okay, Representative Larson, please.
Thank you, Mr. Chairman. Senator Rothfuss, you've talked about how we kind of want to see this go for a few years and see the effects of it and whether that has helped our constituents in Wyoming. I don't see a reporting provision in here for any agencies. Was that discussed in your committee? And if not, do you think that that's something we should try to look into, is should our state agencies report on how they've implemented this act if we decide not to move forward with so-called teeth? What are your thoughts?
Senator?
Mr. Chairman, Representative, the only concern I have there is that it's literally every agency, every political subdivision of the state that this then applies to. You'll see we have ETS start off with creating some sample policies on what it might or should look like. And then we have on the C paragraph, which is the next paragraph, some requirements. So we expect that to roll out. We were kind of anticipating hearing organic feedback based on concerns that would be raised as it was rolling out, and you know, put it back on our agenda, have agencies come in and tell us if something was problematic, and sort of reach out that way. But I don't know who we would tag with a reporting requirement necessarily, since it's everybody. And you have a variation in, you know, you have some agencies that University of Wyoming expressed that this would be a reasonably heavy lift for them. Other agencies were like, yeah, it'll take us 20 hours of work. So broad variety in their initial estimates on how challenging it's going to be for them to implement this act. I'm not averse in any way to a reporting requirement. I just don't know who we would necessarily tag that with.
Follow-up, Representative?
Thank you, Mr. Chairman. What are your thoughts on maybe having some, like maybe the governor do at random, like 5 agencies or something? So it's just at random. It's not putting a burden on the entire system, but it does give us some information. What are your thoughts there? And then I do have another question that's not related in this path after that.
Senator?
Mr. Chairman, Representative, yeah, maybe just tasking the governor's office with doing an audit of some sort would be a reasonable way, and then reporting back to the Blockchain Select Committee and potentially the Minerals Committee on the efficacy of it. I think that would be a rational approach, and then leave it up to at that point, yes, you'd presume the governor would then send out, you know, a note to agency heads and saying, hey, you know, do you have any feedback on this? That's a workable approach.
Okay. You had another question, Representative?
Thank you, Mr. Chairman. And then on the law enforcement agency definition, I think what you're trying to get is to officers, well, agencies that have officers that go through the post academy. Is that accurate? So it's like, I was reading the college or university police force line and thought about, well, not all colleges have a police force, but they do have security. Did you want that to apply to college security, or just people who have gone through post?
Mr. Chairman, Representative, it probably is just people that have gone through post and their direct agency, but you can see the way we were structuring it is if you are what we would think of directly as law enforcement, criminal enforcement, you've got prevention or investigation of crime or the enforcement of penal, traffic, regulatory, or criminal laws. It was odd that in statute that didn't already exist. And so you've got agencies, for example, Game and Fish, you have law enforcement that are enforcing laws, and that particular portion would be carved out, but Game and Fish isn't carved out, even though they're a law enforcement agency, because they have laws that they enforce. So we tried to structure it so that those that are enforcing laws and their direct administrative unit are clear. But just because you have a law enforcement, YDOT, right? They have a law enforcement capacity, but what percentage is their law enforcement of the entity? So we tried to structure a definition so that we carved out the administrative units of law enforcement in all their capacities, but left all of the non-law enforcement administrative units still responsible. That was our intent.
Okay, Senator, let's pull this back to where we're
Yes.
going back through the bill.
Let's do it.
And we're on
Yep.
paragraph B on page 8, talking about the overcollection concept. And as I understand this would be a government entity asking for your social security number when they really don't need your social security number.
That
It's
is a
just
perfect
convenient for
example.
them, for their filing system, but they don't need that. So this would prevent that. So let's continue on from here.
Thank you, Mr. Chairman. The C paragraph, it talks about data retention. It says that you're going to have not more than 3 years to retain any specific data unless you have a express written policy identifying the extended retention period and providing a reasonable justification for the extended retention period. And then the last language, statutory retention requirements provided for in statute that you see there constitute a reasonable justification. That's the state archives. And so there are certain archival obligations through statute already. And so this is a call out the archives asked for to make it clear that everybody should be reading that before they make a decision on their timeline. So there are no restrictions here. If you write down on a piece of paper, we want to keep this data for 10 years. Okay, but you have to have a reason. You have to write a reason down afterwards. So again, not holding anyone back from whatever business practices they think are in the public interest, but it gets to, don't just keep it in the filing cabinet because we don't want to throw it away because it's too much work. That's not a justification that's in the public's interest. So this requires a data retention policy, or if lacking a policy, throw it away within 3 years. And then the D paragraph is, again, if you're compliant with the data retention policies in HIPAA or FERPA, if you have a compliant policy, you are deemed compliant under statute, because they have already, through HIPAA and FERPA, federal laws, ridiculously complicated data management policies. And so rather than having them comply with two, we have basically said if you're complying with HIPAA or FERPA and you have a written policy that does so, you're deemed compliant with this statute. Page 9, section 3, this tasks ETS with setting up sample policies for use by state agencies, cities, towns, and counties, et cetera. Section 4, it's a little complicated way of structuring it, but this is a phased-in effective date where state agencies start off when this act becomes, or in 2026, you'll see that there's a delay of a year. So state agencies start off at 2026, cities, towns, and counties, July 1st, 2027, and then anybody else not on those two lists, July 1st, 2028, they would have to be compliant with this. So long opportunity to get compliant. And then on page 10, section 5 talks about, you know, the meat of this bill with specific policies in section 2 becomes effective on July 1st, 2026. So you've got more than a full year to get on board. And then those that are just requiring rulemaking and studying, et cetera, become effective immediately. So That's the bill, Mr. Chairman. Happy to answer any further questions. We put a lot of work into it and really talked through a lot of potential concerns and exceptions with agencies. Spent a lot of time readjusting this to find pathways for legitimate use and legitimate applications to be appropriately covered, and any place where you have obligations under statute are also explicitly covered.
All right, thank you, Senator. You've put a lot of work into this over the past 2 years to come up with this. We have an engrossed version. Could you tell us what was amended or changed in your chamber?
Yes, Mr. Chairman, it's going to be a little bit off the top of my head because I don't have those amendments in front of me. I should have brought them. But we tweaked the HIPAA language, and this was a request. So the 2 paragraphs, this is on page 5, Romanet 4. It existed, but we tweaked it to make it a little bit clearer. And then on page 8, the D paragraph, this was at the request of our healthcare community that felt that the way the language of statute was, they were going to have to comply with HIPAA, and they were going to have to comply with this, and they were feeling that they were basically going to have to do them separately and twice.
Right.
And so in working with them, we put it together so that they would, compliance with HIPAA was sufficient.
Right.
The other paragraph that we put into place, let's see, it is on page 4. We worked on this, and language similar already existed, but the Romanet 2 paragraph about transferring personal data to a non-governmental entity was not well fleshed out, and so we had some groups that, Department of Health was a great example. Department of Health does a lot of contracting out, so they use their data, they work with a company, that company does the actions, and they were worried that we didn't have clear enough language that would allow them to do that, so they felt that they were going to have to get an exception through the governor's office every 2 years to do what they do. So we worked on that, and we had a few other entities that came in, and in listening to that, we made that Romanet 2 paragraph much better and clearer and seemed to have satisfied those interests.
All right, thank you, Senator. Questions for the Senator? Representative Schmidt, please.
Thank you, Mr. Chairman. Good morning, Senator.
Good morning.
Maybe we touched on this. If we did, I missed it, but I'm going to ask the question. Does this bill limit any access to government-held data that is currently public?
Senator?
Mr. Chairman, the only way, it doesn't limit access, but it might say stop retaining it. Although if it is a true public record, it ends up through the archives, going into archives for a certain data retention policy under current statute, and it would not change any of that. So any current public record pursuant to the Public Records Act is still a public record pursuant to the Public Records Act. On the collection side, as we mentioned, we over-collect. Those over-collections are public records. So this would probably, hopefully, stop some of the over-collection and would limit what data the government doesn't need to have that it currently has as a public record. And that kind of thing happens all the time. The university used to have to give out so much information because they over-collected. And for athletics, for example, massive over-collection, certain like television networks would come in and ask, we'd like all of the information you have about all of your athletes. Here you go, here's the fire hose. It even included their home addresses. It was great. That did get remedied, but it got remedied through realizing maybe we shouldn't collect that information.
Okay.
Follow up?
One more question, Mr. Chairman. Senator, what about if this bill goes forward and is passed? Do you anticipate any of the government agencies needing additional staff or technology to make all this happen?
Mr.
Senator?
Chairman, Representative, you will see in the fiscal note some discussions of administrative impacts which relate to the number of hours different entities expect they'll have to spend on it. Nobody made any requests for additional dollars. Nobody made any requests for additional staff, but they did provide this is going to take us some time depending on what they've got going on. You'll see that we gave them long runway in terms of time to become compliant with the hope that they can just fold this into their standard business practice and take care of it.
And that's all addressed, that time is all addressed in section 4 on page 9. Yeah, okay, very good, thank you.
Thank you, Representative.
I always like it when we put additional burdens on our departments and they say, we don't need more money. We'll just take care of it.
They grumbled, Mr. Chairman. I
Yeah.
can't say they didn't grumble.
Very efficient
Some of them
groups.
said they appreciated it too, even though they were, grumbling on one hand, saying, yeah, this is good policy on the other.
All right, any other questions? Representative? Okay, the staggered implementation, Senator, this is pretty innovative, having all the different timeframes. Can you just provide a little more detail why you went staggered like that with, and which, the entities going into different years that why some of them had more time than others, I guess, Senator?
So ETS is first tasked with setting up examples, and that's by January 1st of 2026. So, and they're fine with it. They think this is great. Did not request anything additional. So they'll create some sample policies on data retention, handling, and management at all the different levels. And then, excuse me, handing those out to the agencies, right? The agencies are closest to ETS and are the most centralized, so state agencies end up having an obligation of July 1 of 2026 for their compliance. Then recognizing cities, towns, and counties, that's another layer of abstraction, kind of as you're thinking about rings of the state government, that's the next layer out, giving them another year. Presumably some of the more larger governments would hopefully be able to do this with internal staff. ETS can work with them, set some better sample policies for the smaller and be able to percolate outward. And then other political subdivisions of the state, other than that, you're talking now things like special districts and other entities that would still have to have compliance and come up with their policies. And those are the ones that are just not used to these types of data handling as well, right? More of a challenge as you move outward on the ring. So that was the thought, was giving them at that point compliance by 2028. You've got more than 3 years to write down some policies. And as you saw, those policies don't have to be particularly complicated, but one of the things it really would do is hopefully discourage entities from bringing in personal data if they don't need personal data, because they'll have to manage it. And right now, with no burden of management, so to speak, in place, just collect everything and just hold on to it and keep it in the drawer over there, and everything will be just fine is kind of the policy. So that was our thought. We didn't want to rush anyone, and again, provides a lot of time for feedback. You can see with if a special district, for example, starts looking at this and saying, hey, we can't do this and here are the reasons, they've got 3.5 years to let us know.
So Senator, by your testimony, the University of Wyoming collects a lot of data that may or may not be necessary, but according to this, would they fall into that 2028 timeframe for the university? And if so, why so late for them?
Mr. Chairman, they do fall into that category, and honestly, that wasn't something we spent a lot of time talking about. Same thing for the colleges, they would fall into that third category. And they have a tremendous amount of information. They could probably do it sooner. If they were doing it by 27, for example, that would be perfectly reasonable there. They have the wherewithal.
Okay, all right, thank you. Any other questions? Seeing none, thank you very much.
Thank you,
Senator.
appreciate it,
Don't
Mr.
go
Chairman.
away.
Yep,
We're
I'll
gonna
be
hear
right
from you
over there.
again. All right, any other state agencies that would like to provide testimony on this? Joe, we'll start with you and Secretary of State's office. Welcome, good morning.
Thank you, Mr. Chairman. Joe Rubino, I'm the Policy Director and General Counsel for the Secretary of State's office. Appreciate you letting me speak this morning and testify on the bill. Wanted to note a couple of things on the bill. That the Secretary is certainly supportive of the concept. We've been monitoring this as it progressed, both last session and this session. I did want to highlight a couple of concerns. And I did hand out a proposed amendment that I'll speak to in just a minute. But I do want to speak to the Secretary of State's office's role specifically with respect to management of our statewide voter registration list, our voter rolls, and why it puts the Secretary of State's office and all election offices in sort of a unique position for both the implementation of this bill, and I believe the way that the bill was contemplated. So as a little bit of background, as the Wyoming Secretary of State, our office is charged with maintaining Wyoming's voter rolls, what we call Wyoming's voter registration system, or our voter registry list, which is throughout Title 22, Wyoming's election code. We take this very seriously. It's a huge priority of our administration to make sure that we're maintaining adequate and clean voter rolls. And it's one of the things that all states, all 50 states, were charged with the passage of the Help America Vote Act in 2002. And with the passage of HAVA, as they call it, the Help America Vote Act, each and every state was to develop a standardized system to maintain adequate voter rolls. So when you go to register to vote, you go onto a state's voter rolls and you remain on there while you're active. And then if you become unregistered for whatever reason, you become inactive. But you're still maintained on our voter rolls so that we can ensure that there's no duplicate registrations, that is two people registered to vote in the same state, B, that there's no duplicate registrations across state lines. So in part of carrying out this process and maintaining clean voter rolls with our state to make sure that there's no duplicate voter registrations in our state and another state, our office routinely both send and receive voter registration information, that is registration information that we collect when somebody registers to vote, to other Secretary of State's offices and their elections divisions when someone registers here in Wyoming and they indicate, as prescribed on the Wyoming voter registration application form, which we all fill out when we register to vote at our county clerk's office, that they are currently registered to vote in another state. Our concern with this bill as it's currently written, and we've followed this both with the discussions on this in the when it was in its House of Origin, and it spurred an internal discussion within our office with some of the amendments that were tagged on, although it wasn't perfectly analogous, and I think Senator Rothfuss did a good job of walking through those. We were really discussing the provisions of the bill that require an explicit provision of law to share this information. Well, the sharing of this information, it's absolutely contemplated between states like Wyoming and any other state within both HAVA, the Help America Vote Act, which is federal law, as well as throughout Wyoming's election code. However, we're concerned specifically with the language on page 4, the 921-202, the language, the without express written consent. Excuse me, I'm sorry. Of the natural person, except as otherwise expressly provided by law. We are concerned with that language, and we do feel that it is unclear. I think, that the senator did a good job of walking through the bill about the numerous things that were contemplated. I think some broader exceptions. However, when we reviewed both the Election Code and the Help America Vote Act, they certainly contemplate sharing information between states. The voter registration application form, the election code, it definitely contemplates that as part of the form, what's prescribed on it is a withdrawal. But we do believe, and we are concerned that we need statutory clarity within this bill that would continue our ability to share this information with other states, specifically their Secretary of State's offices. This isn't being shared with someone outside of their official offices, to make sure that there's no duplicate voter registration information. It's very pivotal to election integrity, and it's very pivotal to making sure that we don't have multiple voting registrations across state lines. One of the things that places, I believe, our office in a unique position is really the rollout of the Help America Vote Act, and how while there's a standardized method whereby all 50 states are to maintain their voter registration lists, their voter rolls, and it certainly contemplates that you would share this information in order to make those rolls clean, that you have proper voter roll hygiene. Each state has its own voter registration system. They're not automatically interconnected. And so, again, certainly supportive of the concept. We've been following it. We've had discussions with Senator Rothfuss on it. I did reach out to Senator Rothfuss about this conceptual amendment. I do understand, his concerns, and I'd be happy to let him speak to it about, well, each agency would just come up with their own exception. I do believe that our office and the Secretary of State's office in the elections realm, it is in a unique position, and it is in a position that other state agencies are not necessarily in a position in. And that is that it both contemplates sharing information, but we are charged with our own voter registration system as are other states. So I'm happy to take any questions. Just to walk through the amendment. It's on page 5, line 19, inserting a new Romanet 5, and just providing that nothing in this subsection shall be construed to prohibit the Secretary of State from transmitting voter registration data to state or local election officials in other states consistent with the Help America Vote Act to prevent duplicate voter registrations and otherwise maintain accurate voter registration systems and lists.
Thank you, Mr. Rubino. Any questions for the Secretary of State's office? Mr. Rubino, with this proposed amendment, and as you transmit this information to other states and other counties or entities outside of the state, would that be, do you routinely include a clause in there that this is confidential information and should not be shared by the entity that's receiving it? So for example, if you transmit this information to another state, could they then sell or give that information to other entities? Is there some clause that you protect the confidentiality or require them to continue to protect that confidentiality once you transmit that data?
Thank you, Mr. Chairman, and I'm glad that you asked that question. So different states handle their voter registration withdrawal notices differently. As you can imagine, in some states, it's hard to get off of their voter rolls. What we do in our standardized process, what we send to other states, so this would be exactly what's contemplated in the bill, is the voter registration withdrawal report that's sent by our elections division, and it does. It has in big, bold letters in red font at the top that this is confidential information and not to be for public consumption or release to the public. We've never had an issue with anything that we've shared. Again, we're sharing these with other election officials that have the same data for their registrants in other states. And typically what you have when these happen is that someone, say they move from Colorado to Wyoming, and so they're currently registered down in Larimer County. And what this does is it enables our office to send this notice to them, so it will ping their office to make sure, hey, this individual moved up to Laramie County, Wyoming, they registered to vote, they should be taken off your voter rolls. And so, yeah, it's right up at the top that it's confidential and not for public consumption.
All right, thank you very much. Any further questions for Mr. Rubino? Seeing none, thank you very much for your testimony. All right, other agencies of the state. Good morning, welcome.
Mr. Chair, Jeff Kleins, I'm the Director of ETS, State CAO. we're neutral on the bill, but I wanted to identify myself and answer any questions the committee may have.
Mr. Kleins, why are you neutral?
That's the position of the governor's office is neutral on the bill. We understand the value and difficulty in both sides to implement it.
And Mr. Kleins, do you see this having any impact on the governor's office?
I can't speak to the governor's office. They don't collect a lot of data, in comparison to other state agencies, so I can't imagine it would be a substantial impact.
Okay, thank you. Any questions for Mr. Kleins? Seeing none, thank you very much. Any other agencies of the state in the room? Any citizens in the room that would like to provide testimony? Any citizens? Not seeing, I see some citizens, but they're shaking their heads or head, just one. Mr. Meyer, it's time for those that represent businesses and then other entities to come forward and provide testimony. Thank you for being here, Mr. Meyer.
Good morning, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. I will tell you that our members really didn't have to take a position on this. We're just kind of watching it. But there was a question today that by Representative Lawley that made me stop and look at this. So it certainly was not my intention to blindside the good senator who is presenting the bill. It was a question that just popped up. But when you start talking about the Public Records Act, and there's several sections in there that says unless otherwise provided by law, this may be that law, I'm not sure. But my concern is, and I don't know if we've heard anything, and I don't know if the good senator has heard anything from like the title companies, but from a lender's perspective, since we don't really identify and define transfer, I don't know how all this would apply to real estate records that the county assessor would have, because I don't see an exception for them. That's public stuff, but lenders would definitely want to have some idea if they're lending and having a loan secured by real property as to what was going on that property. So I'm not complaining, I'm just looking for some explaining, I guess, and that is our only concern as I sit here today. But other than that, we don't have a position on the bill, Mr. Chairman.
Thank you, Mr. Meyer. Any questions for Mr. Meyer? Seeing none, thank you very much. Any other individuals representing business entities in the room? Anyone else in the room that would like to provide testimony? Anyone else in the room? With that, we'll go to Zoom. We have one online.
Dixie Huxtable.
Ms. Huxtable. Good morning, Ms. Huxtable.
Good morning, Chairman, members of the committee. Dixie Huxtable, Converse County Assessor. The last speaker just actually brought some of the thoughts that we had. We really don't have a position on this bill. We've just been watching it. Most of our data in our assessor's offices is public information. There is specific by rule and by law that's confidential. And certainly we have the distinction between the two. I think the assessor's conversation was, how does putting our public data out there on a website, a map server where somebody can identify where your property is by your name, if that could be any way construed in this bill that we'd be in violation. And I think that's the only concern we have. We don't believe there is. We think our information is public. And so we don't think there's a problem. The retention that was talked about, we follow the archives with most of our public records. So I don't think we have a problem with it. We just wanted to be clear that that we can still serve it to the public as we always have without any kind of violation. With that, we'd stand for any question.
Thank you, Ms. Huxtable. Any questions? Seeing no questions from the committee, thank you very much for your time. Any others on Zoom, Mark? Okay. Senator, would you like to provide any additional testimony before we close this out?
Thank you, Mr. Chairman. Starting with assessors and title companies and that discussion that we just had first. What they release and transmit are public records. We did I talked through this with my clerk and with others, and the last testimony is my understanding. This is a public record. Now, you do have an elected official there also, if they get to the point where they're struggling and they're like, well, wow, this is something that we provide and we're running into statutory problems. That elected official would be able to provide a suspension or a little letter justifying it. Once we see those, if we see any concerns, we could address those, but it is anticipated, has been discussed, and the reason they can release those, the reason they can do what they're doing right now under statute is because those are deemed public records. So, yeah, that's something that I feel comfortable with. Getting to the concerns of the Secretary of State's office, again, this is an interesting one, and I appreciate having conversations with, and some email back and forth with the Secretary of State's office on this idea of voter rolls. This does get into the special unicorn concern that I kind of mentioned earlier, which is everybody's got a little case where they're like, well, it's not specifically covered maybe in detail, and let's call it out as an exception. This is one that seems like, I guess I would say this, either they have the statutory authority as the Secretary of State's office to share voter rolls, in which case they can already do it, or they don't, and why should they be allowed to do it? So at that point, it would come back to one of these provisions. You've got Romanet 1 on page 4, that a government entity may transfer personal data to another government entity provided that the other government entity complies with the article. So it gets to your question, Mr. Chairman.
Yes.
Are they complying with the article? So we would have to force them by contract and say, you can't sell this data. What would stop them now? I don't know what would stop them now. So if we're giving our data rolls to another state, either there's statute in place that governs this or there's not, and we should be governing it and say, don't sell or transfer that data and delete it when you're done with it. That's good policy. If somehow that doesn't cover it, then once again, it would literally be the Secretary of State on page 5, Romanet 3, having to sign a letter if there are no laws that allow it, and maybe an AG opinion comes back and says, wow, you can't do this, the Secretary of State would have to sign a written, we are going to share data with these other states. This is consistent with complying with HAVA, but we don't see a specific exemption. And then that letter would have to be reauthorized every couple of years. That would flag an interesting point for debate, though. If they don't have the authority to share that voter information, that'd be a great letter to see. But I think they do. So I don't see the need for the amendment, and I do appreciate having the conversation beforehand. That was what I suggested, was that this legislation is crafted to account for this particular unicorn as well. And in fact, it's probably one of the easiest challenges I heard, because you literally have the Secretary of State right there as the entity that can just sign the letter immediately if it's deemed a problem. And I don't see that there's that much of a burden signing a public letter every couple of years if it is deemed that Romanet 1 can't be complied with. But the beauty of it was you would have to justify somehow to the public, we're going to give our data to states, we're going to give our voter registration data to states that are not going to comply with this act. That would basically be what you're signing, and the public should know that, and they should be concerned. And then the final point is a substantial portion of those voter records I know are public records under Wyoming, but not all of it. So it's probably only a portion that falls outside of the Public Records Act anyway. So those were my thoughts when discussing this with the Secretary of State's office, is that the legislation meets this case study very well.
Thank you, Senator.
Yes,
Any
thank you.
questions for the Senator? Seeing none, thank you.
Thank you.
With that, we will close public testimony. Members of the committee, what's your pleasure? Moved by Representative Larson, seconded. Seconded by Representative Schmidt. All right, let's walk through the bill quickly. Any discussion on page 1? Page 2? 3? 4? Any discussion on page 5? Page 6. 7. Anything on page 8? Page 9. Representative Larson.
Thank you, Mr. Chairman. I'm going to move a conceptual amendment to require that the Office of the Governor do an audit of state agencies under his authority on the compliance of this act.
Okay. And where would that audit, or where would that wording be placed?
I think I don't know if it's going to create another section between Section 3 and Section 4 as it reads in the bill currently, or if it's going to just be added to Section 3, but somewhere in that range, I would imagine, an LSO can.
Okay, do I hear a second? Do I hear a second? Lack of a second, that motion, that fails. Okay, anything else on page 9? I will propose an amendment on page 9, line 8. It says, "This act shall be effective as to counties, cities, or towns." I would propose we add public institutions in there and say counties, cities, comma, strike or, towns, comma, and then or public education agencies or entities. We heard through testimony that they could comply earlier than 2028, that they could actually do 2027. Higher education, okay. Public higher education. And would you call those agencies, entities, or just higher education? Institutions. Thank you for allowing me to phone a friend.
Clarification?
So it would be counties, cities, comma, striking or on line 8, towns, adding a comma, or higher public education institutions. Public higher education institutions. Do I have a second? Seconded by Representative Larson. Any discussion? Do I hear a question? Question being called. All those in favor of Chairman Heiner's proposed amendment on page 9, line 8, signify by saying aye.
Aye.
Any opposed? Okay. Anything else on page 9 and page 10? All right. Any discussion on the bill? Question being called. Thank you. Mark, this will be a roll call on Senate File 65, Data Privacy Government Entities as amended. Would you please call the roll?
Representative Campbell.
I'm aye.
Representative Knapp has voted no. Representative Larson.
Aye.
Representative Lawley has voted aye. Representative Riggins.
Excused?
Representative Schmidt.
Aye.
Representative Tarver.
Aye.
Representative Weber has voted aye. Chairman Heiner.
Aye. All right, Senate File 65 has passed this committee with a recommendation of due pass. Who will carry this on the floor, Senator? Do you have any choices? Singing sing, huh? Okay, thank you very much. Okay, all right, we'll do that. All right, thank you. We'll now move on to Senate File 53, trademarks and trade names. Mr. Rubino, thank you for being here. Appreciate the Secretary of State's office being here to present this bill for us and explain all the intricacies. So please proceed.
Thank you, Mr. Chairman, and good morning, Mr. Chairman, members of the committee. Again, Joe Rubino. I'm the Policy Director and General Counsel with the Secretary of State's Office, joined by Colin Crossman. Colin is the Director of our Business Division at the Secretary of State's Office. We just wanted to speak to you about Senate File 53. This was originally proposed by our office as a Joint Corporations Committee interim topic, and we're very supportive of the bill. The Secretary is very supportive of the bill. We appreciate the work of the committee on the interim on this very important issue, both as part of the Business Fraud Working Group and throughout the interim Joint Corporations Committee meetings in Lander, Evanston, and here in Cheyenne. The result, I think that you'll see, and this is the original introduced version. It was a very well vetted bill and discussed multiple times throughout the interim. It pertains to our office's original request for an exploration of ways that our office can better serve the public when instances of fraud, misstatements, or misuse of trade names or trademarks occur without forcing those individuals to automatically resort to judicial intervention, get an attorney, and go to court. As we outlined during the Corporations Committee meetings in April and August in the 2024 interim, the grounds for dissolution of trade names and trademarks are far more limited than those of other business entities registered with the Secretary of State's office, such as for-profit corporations, nonprofit corporations, limited liability companies, etc. Unlike corporations or LLCs, holders of trade names and trademarks, with limited exceptions, commonly have to resort to costly and time-consuming litigation in instances of false or fraudulent filings interfering with their holdings. So, Mr. Chairman, I know that was sort of an introduction to the background of the bill. With your permission at this time, now I'd like to walk through the bill, if that's all right.
Please do, Mr.
All right.
Rubino.
Mr. Chairman, on page 1, this really adds a new ground of cancellation. Of course, you have the description that it's authorizing new grounds for administrative dissolution of trademarks, service marks, and trade names as specified in the bill, and providing the right to appeal administrative cancellations, something that's key. It's one of the things that we've discussed at length throughout the interim, sort of the processes in place that we have with our office, with our existing administrative dissolutions, and then, of course, providing for an effective date. So beginning with section 1, we're amending, these are the trademark statutes in Title 40, creating a new Romanet 6 in 40-2-107A for a new ground of cancellation of registration of a trademark. And what we have is that the Secretary of State shall cancel from the register in whole or in part. Romanet 6, this is really expanding on what originally we had. I'm looking at existing language just as background. You have voluntary cancellation. So when the holder of a trademark withdraws their registration, when they're not renewed, and in the case of a court order. What this adds is Romanet 6, any registration if the Secretary finds that cancellation is in the public interest and that the applicant or registrant has provided fraudulent information or has failed to correct false information upon request of the Secretary on any filing under this act, subject to the following. A, details that the Secretary shall send written notice to the holder of the determination by certified mail. B is a time to cure, 60 days for the holder of the mark to cure, and provide written notice and the opportunity to cure. C, if the registrant's response does not demonstrate to the reasonable satisfaction of the Secretary of State that each ground determined by the Secretary for cancellation does not exist or the registrant does not respond, the Secretary shall cancel the registration and send notice of the cancellation of the registration by certified mail. And D, the ability of the registrant to appeal the cancellation to a district court within 30 days after written notice of cancellation. and some appropriate safeguards there, allowing for the district court to summarily reinstate the canceled registration. Again, at the bottom of page 3, dealing with the amendments to Wyoming Statute 40-2-107, this deals with identical language with trade names. So again, adding a new ground for cancellation, for administrative cancellation. Again, this is parroting what is already in existing statute, the grounds for administrative cancellation for other business entity types that are registered with our office. So if someone files a false or fraudulent document with our office for a corporation, for-profit, nonprofit, or a limited liability company, this is parroting and mirroring that language now for trade names onto page 4. So adding a new Romanet 4, again, this is the same language that we went through. Any registration, if the secretary finds that the cancellation is A, in the public interest, and that the applicant or registrant has provided fraudulent information or failed to correct any false information with our office. Capital A, if the secretary determines that grounds for cancellation shall exist, then the secretary sends the registrant written notice and an explanation for this determination. Capital B, again, is the right to cure, the 60 days for the registrant or applicant to provide any grounds to satisfy and cure this issue. At the bottom of page 4, going on to page 5, capital C, if the registrant's response isn't to the satisfaction, this is again mirroring what's in existing statute for corporations and LLCs, then the secretary shall cancel the trade name. And D, again, this is the right of the registrant to appeal any determination to a court of competent jurisdiction and enabling the court to summarily reinstate. On to page 6, section 2, it's just that this is effective July 1st of 2025. Mr. Chairman, I just have a couple more remarks if there aren't any more questions, and then I'd like to yield over to Mr. Crossman, the director of our business division, to outline the implementation of this bill and a couple of the system changes that it would require.
Please proceed.
Okay.
I see no questions at this time.
So again, I just want to reiterate, as we did numerous times throughout the Joint Corporations Committee interim meetings, that while this does expand the ability to take action if there is false or fraudulent information, this is part of a number of bills that were forwarded by our office that are making their way through the legislative process. This does mirror the same statutes that we have in place for other business entities, and it does have appropriate safeguards. So, Mr. Chairman, if I'll go ahead and have Mr. Crossman go through both how we handle right now, I think briefly, our administrative dissolution process for other business entities. I think that'd be very valuable for the committee. The right of those entities to take action if there's a false or fraudulent filing on their behalf, and then the process that we go through in making sure that we can take action while also providing that there's appropriate safeguards in place if there's anything that's been provided to our office that's wrong or any opportunity to correct.
All right. Thank you, Mr. Rubino. I look forward to Mr. Crossman explaining that process that is in place right now. That would answer some of my questions.
All right, thank you, Mr. Chairman. So,
Would you introduce yourself first,
oh,
Mr.
sorry, yes.
Crossman?
Colin Crossman, Director of the Business Division. Thank you, Mr. Chairman. I'll take, for example, Wyoming Statute 1716, 1420. It's not reproduced here, but this is the statute that deals with how we handle dissolutions for these kinds of things in a for-profit context, which is where most of this language is actually taken from. In those situations, if we're presented with information, we don't take unauthenticated information. Someone has to provide us with an affidavit or something more than just an email or a phone call saying this is false. So they have to put themselves, subject to perjury charges or something like that, so that we have some confidence that it's not just people playing around with each other. But once we have that, we will do an investigation into that to see if it passes the sniff test. If it does, then we'll go into what would be, say, on page 2, subsection B, where we prepare A and B. We prepare a grounds for cancellation and send that to the, in this case, the registrant. And that person would then have 60 days to provide us with some justification as to what's going on. In one case, for instance, in a business context, we had a business that had placed, that had used the address that they didn't have authorization to. This is how most of these things happen. In most cases, it actually is fraud. In this particular case I'm explaining, it turns out that the business had just transposed the numbers. And so when we got it back from the business saying, oh, I mistook, this is my real address, here's some proof. Okay, we canceled the cancellation and everything went on like normal. So there's safeguards at every level here. And it's a fairly, this is a process that only myself and the other senior staff can do. This is not something that we give to the line level registrars in our office. This is a higher level thing that requires, investigation and judgment. And we take it seriously. But if we're wrong, then there's a process in both in the older 17, 16, 14, 20 for organizations, as well as in these new things that are being added, that the applicant or registrant can go to the court and have us overturned if for some reason they completely disagree with our determination.
Okay, thank you, Mr. Crossman. So any questions for Mr. Representative Larson? Yes.
Thank you, Mr. Chairman, and this may go to either one of you, so whichever wants to take this up. You mentioned that this language is just mirroring other, that's the statute that's already in place in other parts of our statute. And I just wanted to know if there was any discussion in the interim committee regarding the 30-day timeline for court appeal, and whether that was appropriate, or if you feel that needs to be extended to give more time for the business or trademark holder. Just your thoughts.
Mr. Rubino.
Thank you, Mr. Chairman. Representative Larson, yeah, happy to answer that. I'm trying to recall a couple of the discussions. I know that surrounding a couple of other bills, for example, new grounds for cancellation for an entity that's found to be owned or controlled by a foreign adversary. These things, they did come up, I would say, tangentially. I think that's existing statute. There's no indication that we've received, especially with the notice that's sent to the entity, that if there is something that is wrong and they did not take 60 days after notice to their representative to cure it, that there would not be ample time to then go and do that. And I certainly appreciate the question. But when we went through this and we're going through this on some of the other bills, it's one of the few areas where there's actually quite a bit of exhaustion in the administrative realm before you would get to any judicial process, whereby you're notified and then you're allowed the opportunity to cure. And in the case of exactly what Mr. Crossman described, I think that's the key case there, is where there's sort of a number transposed or something like that. Then somebody can contact our office, and of course that was remedied right away. So I think that's a policy decision, but I think that I'd be hesitant to mess with existing statute when I've received no indication that has been an issue to date.
Mr. Crossman.
Yeah, thank you, Mr. Chairman. Representative Larson, in every case where we have had an entity challenge our determination, it has happened within 7 to 10 days. It was, and in every case where there was a challenge, in all but one cases where there was a challenge, we, they had provided a good response, and we unraveled everything. But it was always very fast. There hasn't been a situation that I can think of where someone waited right up to the end or even beyond the end, and then complained. And also, these do require certified mailings.
All right, follow up? Any other questions? Seeing none, thank you very much, Mr. Rubino, Mr. Crossman. Appreciate your testimony. Anyone else in the room that would like to provide testimony on Senate File 53? Anyone in the room? Anyone on Zoom? All right, with that, we will close public testimony. Members of the committee, what's your pleasure? Moved by Representative Campbell, seconded by Representative Schmidt. Any discussion? Do we need to walk through this bill, or any discussion? Any discussion?
Question?
Question being called. Thank you very much. Mark, we're voting on Senate File 53, trademarks and trade names administrative cancellation. There are no amendments. This will be a roll call vote. Please proceed, Mark.
Representative Campbell.
Aye.
Representative Knapp has voted aye. Representative Larson.
Aye.
Representative Lawley has voted aye. Representative Riggins.
Excused?
Representative Schmidt.
Aye.
Representative Tarver.
Aye.
Representative Weber has voted aye. Chairman Heiner.
Aye.
Vote is 8-0 and 1.
With one excused. Joe, do you have anyone that's going to carry this on the floor? Would you do that, please? Let me know who you want to carry that on the floor. All right, thank you. All right, moving on, we will now hear our next Senate file for resolution on commercial baseload power generation. Senator Pearson, welcome to our little community of minerals. Would you state your name and please proceed?
Thank you, Chairman Heiner and members of the committee. My name is Laura Pearson, Senate District 14. I'm so happy to be in front of you today. This resolution was brought to me from a member of the Lincoln County Republican Party and was passed by the Senate, or by the state Wyoming Republican Party at their Central Committee meeting this past November. So I'll go through the resolution with you. This resolution says, a joint resolution requesting the governor concentrate on promoting stable, dispatchable baseload power resources from Wyoming in lieu of taxpayer subsidized commercial wind and solar generated power. Whereas Wyoming produces 4 of the cleanest resources of stable, dispatchable baseload power generation in the United States: clean coal, natural gas, uranium, and hydroelectric. Whereas Wyoming has the ability to provide these resources to the rest of the United States and the world for stable, dispatchable baseload power generation. Now therefore be it resolved by the members of the legislature of the state of Wyoming that the legislature of the state of Wyoming respectfully requests the governor to oppose future promotion and subsidization of commercial wind and solar power generation in the state of Wyoming and promote efforts that provide Wyoming's stable, dispatchable baseload energy to all of Wyoming's citizens. The legislature further requests the governor to promote the export of Wyoming's stable, dispatchable baseload energy resources to the rest of the United States and the world. So that's the basis of this resolution. I'm just going to go over a few talking points here. So energy reliability and grid stability. Baseload power is essential, unlike wind and solar. Coal, natural gas, nuclear, and hydro provide continuous dispatchable power, meaning they are reliable regardless of weather conditions. Wind and solar are intermittent. Renewable resources depend on the sun and wind, requiring backup from fossil fuels or nuclear to ensure a stable power grid. Blackouts and grid failure risks. Over-reliance on intermittent renewables has contributed to grid instability in states like California and Texas, leading to rolling blackouts and energy crises. Wyoming should prioritize reliability over politically driven energy trends. Economic benefits and job protection. Wyoming's economy depends on traditional energy, coal, natural gas, and uranium, providing high-paying jobs and sustaining local economies. Energy industry tax revenues fund public services. These industries contribute heavily to Wyoming state budgets, funding schools, infrastructure, and local governments. Wind and solar create fewer long-term jobs. While renewable energy projects create some construction jobs, long-term operations and maintenance jobs are far fewer compared to fossil fuels and nuclear. Opposing taxpayer fund subsidies for renewables. Government shouldn't pick winners and losers. Wind and solar are heavily dependent on federal subsidies and tax incentives. If they were truly competitive, they wouldn't need taxpayer support. Renewables drain public funds without paying their fair share. Wind and solar farms often receive tax exemptions and incentives while contributing less in taxes compared to traditional energy sectors. Promoting Wyoming's energy exports. Energy exports boost Wyoming's economy. Coal, natural gas, and nuclear resources position Wyoming as a key energy exporter. Strengthening these industries ensures economic security for the state. Foreign demand for reliable power. Many countries are investing in nuclear and coal-fired power plants to ensure stable electricity. Wyoming can capitalize on this demand. Environmental reality check. Clean coal and modern fossil fuel technology reduce emissions. Wyoming is already a leader in carbon capture and clean coal technologies. Wind and solar have hidden environmental costs. Wind turbines require massive land use, harm wildlife, and create non-recyclable waste from turbine blades. Solar panels require rare earth minerals, which are largely mined in China under environmentally harmful conditions. In conclusion, President Donald J. Trump's first day of office, he signed an executive order that attempts to slow the growth in wind generation. The order directed all federal agencies to pause all new or renewed approvals, rights-of-way permits, leases, or loans for onshore or offshore wind projects until the Secretary of the Interior completes a comprehensive review of the federal leasing and permitting practices. Wyoming residents are becoming increasingly aware of the inefficiencies of this green energy. They are tired of their hard-earned money being used to subsidize these measures at the demand of surrounding states. They are tired of our lands becoming dumping grounds, and they are tired of the destruction of our beautiful scenic byways and our beautiful wildlife corridors. Don't California our Wyoming. We must protect our state. Please vote in favor of this resolution. Thank you.
Thank you, Senator. Any questions for the senator? Representative Schmidt, please.
Thank you, Mr. Chairman. Good morning, Senator.
Good morning.
I see you referenced the dumping grounds. I was going to ask a question. I mean, that's one thing that with our renewables that we have a huge challenge with is once they're decommissioned and what we do with the blades and the panels and all the associated hardware and pieces. So something we don't see with our traditional industries that
Yes.
produce this power. So I guess it was more of a statement than a question.
All right,
All
well,
right.
thank you.
Thank you.
Thank you for that. Wouldn't you agree, Senator?
I would.
All right, thank you. Any other questions for the senator? Seeing none, thank you very much for your testimony. Any state no elected officials in the room? Any state agencies that would like to provide testimony? Any citizens that would like to provide testimony? We enjoy citizens being here. This is so neat to have the citizens be able to actually be here and provide testimony. I know it's a sacrifice for you to be away from home. Thank you for being here. Please state your name for the record and proceed.
Chairman Heiner and members of the committee, I'm Dawn Markwart from LaBarge. I'm honored today that the good senator from southwestern Wyoming has brought forward my Lincoln County Central Committee resolution. I want to explain why this resolution is important. Last spring, I attended a Bureau of Land Management meeting on a proposed wind farm stretching from the Jim Bridger Power Plant in Sweetwater County east to Carbon County. I found it concerning that the project moved forward while the fight over the Rock Springs Resource Management project was unresolved. By October, Wyoming faced uncertainty. We didn't know who would win the presidency, nor did we know the final recorded decision for the Rock Springs Management Plan. That uncertainty highlighted the need for Wyoming to take a firm stand in support of dispatchable baseload power, reliable power that sustains our economy and communities. For too long, Wyoming's economy had been at the mercy of outside forces swinging between the boom and bust cycles. It's time for our state to take charge of its own energy future, ensuring long-term economic stability through policies that prioritize our abundant, reliable resources. With President Donald J. Trump's renewed focus on energy independence, we have a key opportunity. Let's establish a strong state policy that secures Wyoming's position as a leader in energy and provides lasting economic strength for our communities. I urge you to support SJ4. Thank you.
Thank you, Don. Appreciate that. Any questions? Seeing no questions, thank you for being here. Appreciate that. Anyone else in the room that would like to provide testimony on SJ4? Anyone in the room? We have two people by the same name online.
Scott Zimmerman.
All right, Mr. Zimmerman, it looks like you've signed up twice, so you get to speak a little bit extra long. Can't hear you yet, Mr. Zimmerman.
Out of work now.
Yeah, there, we got it.
Mr. Chairman, thank you for this opportunity. I'm Scott Zimmerman, and I represent Rocky Mountain Farmers Union. Our members are concerned about this resolution. Number one, resolutions tend not to have much teeth in them, so it probably won't make much difference one way or the other. But a lot of our members have the opportunity to lease land for wind systems or wind turbines, whereas they have no opportunity to have coal or oil in their properties. So the opportunity to capitalize on energy sources relies solely with solar or wind. While we don't condone subsidizing those industries, we do feel that it is not the state's business to dictate whether wind or solar should be an option for a private property owner any place in Wyoming other than the public land areas of the state. And with that, I would take any questions. Thank you.
Thank you, Mr. Zimmerman. Any questions for Mr. Zimmerman? Mr. Zimmerman, wind power is tax exempt for a number of years in the state of Wyoming. Do you believe that we should remove that tax exemption or continue on exempting wind turbines from tax?
Mr. Chairman, I represented a couple wind companies back in the days when that exemption was put in place. At the time, it was instituted because those people had already made a commitment to Wyoming and had their financing and everything in place, and the state didn't feel it was proper to pull the rug out from under them and put a new tax on them at that time. I don't have a real opinion whether we should continue that tax. I know there are groups that feel it shouldn't have been in place in the first place, but I'm really not clear one way or the other whether that should be a continuation.
Thank you, Mr. Zimmerman. As a follow-up to that, do you feel like being tax exempt is actually subsidizing the wind industry in Wyoming?
I think it subsidizes to a certain extent, much like reducing the severance tax on stripper wells or reducing the severance tax on other forms of oil production. subsidizes those industries at the state level just as well.
So elimination versus reducing, there's a little bit of disparity there. Elimination of any taxes at all versus reducing the burden of the severance taxes on oil wells. So we'll leave it at that, Mr. Zimmerman. I think most of the members of this committee feel like it should be a level playing field. We shouldn't favor one over the other. Each form of energy should be able to stand on its own. Would you agree with that?
I most certainly would, Mr. Chairman.
All right, thank you very much. Any further questions for Mr. Zimmerman? Thank you for being here. Do you want to sign back in for your second shot? It looks like you got 2 names on here.
No, I think I covered it pretty well in the first one. Thank you, sir.
Thank you very much, Mr. Zimmerman. Anyone else in the room? With that, we'll close public testimony on Senate Joint Resolution 4. Members, what's your pleasure? Moved by Vice Chair Tarver, seconded by Representative Campbell. Any discussion on this bill? Vice Chair Tarver, please.
Mr. Chairman, thank you, and I believe the bill addresses it well. If you want to put up solar and if you want to put up wind generation, get after it, but we don't want to subsidize it, and I think that I'm all in support of free enterprise doing what they want, as long as the taxpayers don't have to pay the bill.
Thank you, Representative. Any further discussion? Any further discussion? Question being called. Members, we are voting on Senate Joint Resolution number 4, resolution on commercial baseload power generation. Mark, that will be a roll call vote.
Representative Campbell.
Aye.
Representative Knapp has voted aye. Representative Larson.
Aye.
Representative Lawley has voted aye. Representative Riggins.
Excused?
Representative Schmidt.
Aye.
Representative Tarver.
Aye.
Representative Weber has voted aye. Chairman Heiner.
Aye.
8-0 and 1 excused.
Thank you. So Senate Joint Resolution number 4 has passed. Just squeaked by, as Senator Anderson always says. Do you have anyone that you'd like to carry this on the floor, Senator? So why don't you talk to them first and then get back with me who you would like to carry that. All right, thank you, Senator, for being here. Appreciate you bringing that resolution. Senator Rothfuss, you are just in time. There's a just-in-time planning in business where things show up just as they're needed. You are one of those, so thank you for being back here.
Thank you so much, Mr. Chairman. Mr. Chairman, I bring Senate File 135, Defense of State Banking. And Mr. Chairman, it occurs to me you have a green copy, don't you? You've got a
I've got
copy.
a blue copy.
A blue copy, that's right.
I
You
may
all-
be colorblind.
You all
but-
use blue, we use green. So there was an amendment, and my apologies, I have the original one in front of me and didn't print out the engrossed copy, but I believe there was only one small tweak. Mr. Chairman, Senate File 135, Defense of State Banking, again, was work from the interim. Is there a spare in one of their folders? Actually, that would be handy, that way I'm working on this. That's perfect, thank you so much. That'll help me get the language for the tweak right. Mr. Chairman, Committee, Defense of State Banking 1 was work of the Blockchain Select Committee over this last interim, but it relates to Title 13, and therefore we have to sponsor it as individuals instead of, it has to go through the Minerals Committee because it's Title 13, so we either hand it off to the Minerals Committee or we sponsor it individually. Based on timing, we didn't have the opportunity to get it to the Minerals Committee. So you see it's individually sponsored, but it is from the Blockchain Select Committee, as you can see from the sponsors. So, Mr. Chairman, we have a dual banking system, as you all know, and our dual banking system tries to provide equal footing between Wyoming state chartered banks and federally chartered banks, national banks. In the past, I think that probably worked fairly well, but in recent years, there has been a definite advantage to being, I think, one of those nationally chartered banks. And our special purpose depository institutions that we talked about the other day in particular were targeted heavily and effectively through federal regulation and basically put below, I'll say, nationally chartered banks in a way that led to lawsuits and a lot of pushback, and we're still engaged in those lawsuits. One of the struggles we had as those lawsuits were coming forward was that the state didn't really have standing to be in the lawsuit directly, and so one of these speedy banks had to sue its own regulating entity, which is not a fun thing to do, right? Because you're in business, you're dependent upon that entity that you need to work with, and you're filing a lawsuit against it, and it turns out that federal regulatory entities don't like to be sued, so that's not pleasant. The intent of this short bill is to provide an opportunity for the state to be able to engage in a lawsuit based on the interest of defending the dual banking system and our interests under the dual banking system, instead of requiring a lawsuit by one of those banks. And that's the idea. There's no appropriation, there's no specific directive, but you see that it is work towards establishing the state's interest in the dual banking system explicitly. So you see it's rolled out, as we see on section 1, that when federal financial regulators overreach or abuse their authority in the regulation of Wyoming state chartered banks, the harms extend not only to the bank, but the state of Wyoming itself. And then it goes on to talk about how we've developed innovative banking systems and that federal overreach has held those interests back. On page 2, we have some allowances for the Attorney General that the legislature finds and declares that, and then you see a dual banking system has existed in the United States since 1863. The dual banking system has allowed individual states to be responsive to banking needs, and that the dual banking system has mitigated the tendency of regulators to stifle innovation. The Romanet 2 paragraph indicates that for this dual banking system to work, state and nationally chartered banks must be fairly treated under the law. Romanet 3 indicates that the state of Wyoming has an interest in ensuring that this dual banking system is respected and that our banks are treated fairly, as well as particularly that we're concerned about any disparate treatment caused by Wyoming's innovative but lawful banking laws. That's the little bit of background that is effectively trying to establish, Mr. Chairman, our state's specific interest to effectively gain standing where the state of Wyoming could engage in a lawsuit without having to have an individual bank engaging on behalf of the dual banking system. And then you see we authorize then our Attorney General. The Attorney General may investigate any allegation by a Wyoming state chartered bank of unlawful disparate treatment by federal or other states' regulators. The Attorney General is authorized to take any available action deemed necessary to defend Wyoming's interest in the dual banking system and its interest in assuring that similarly situated Wyoming state chartered banks are fairly treated by other regulatory authorities in the same manner as a nationally chartered or other state chartered bank. So this is not a shall, this is a may. And the idea here is to provide that standing. We cannot force a federal court to give our state standing, but we can certainly try to provide as much of a platform for standing as the state can use. The state did engage they filed an amicus brief. They at one point filed to engage as a party, but the state's interests were actually deemed moot by the court in the particular case that's there right now. And we, the select committee, feel that if the state could have engaged directly and filed that lawsuit directly, we would have been in a better position to defend our state's dual banking interests. This is for all of the state chartered banks. Their interests, you'll hear from our banking association that they struggle to with federal regulation, just like, you know, many different entities do. So this offers the opportunity, but it was the Speedy Bank situation that really brought it to a head where we struggled, and we're still in court right now, awaiting a decision that hopefully will go against the U.S. Federal Reserve and in favor of our Wyoming Speedy Bank. That's what the legislation does. I'm happy to answer any questions.
All right. Thank you, Senator. Any questions for the senator? Senator, was the Attorney General reluctant to get involved with the Speedy Bank litigation?
Mr. Chairman, no, and we did, right? We filed a good amicus brief. We were involved. And as I said, we filed a separate party motion on behalf of the state's interests. Those were deemed moot by the court. So I don't think there was necessarily a reluctance, but we could not be the first to file, so to speak. So we had to have a bank file against the Federal Reserve and their regulators. And that's an unfortunate situation to be in when you're asking for the master account through the Federal Reserve. You're trying, they deny it. Our feeling is it would have been much better for the state on behalf of all of our Speedy Banks, because most of them want master accounts, to be able to step in and say, this is a violation of our dual banking system, and this is against the interests of the state of Wyoming, which it is. So this is an attempt to allow for that so that the regulated entity doesn't have to be the entity that steps in. It still might turn out that way, but it's trying to improve the standing. And I didn't mention the small difference between the original bill and this bill really was a shall to a may, where the original language on page 3 was the Attorney General shall investigate, but then had flexibility as to whether or not they would bring any action. And there was a request by executive branch to make that a may, and we were fine with that. It provides, if the executive branch desires to operate directly, which is what we wanted, they would then have a better position for standing.
Thank you, Senator. Senator, no offense intended, but as I read this bill a couple of days ago, it seemed pretty weak. It's a lot of findings, and then on this last paragraph B on page 3, now a may investigate. There's, you know, the only thing of real teeth that says the Attorney General is authorized to make any available action deemed necessary, but it just doesn't seem to have a lot of statute to it. That's a lot of findings, which we hesitate to do. What's your comment on that?
Mr. Chairman, the findings are actually the key, which is a rare thing, right? It isn't a bunch of shalls, and it doesn't need to be a bunch of shalls. It is us trying to find a way to convince a court that the state has standing in the dual banking system fights. And honestly, findings are strangely the best way we've got to do that, where we're laying out in our statute that we, the legislature, are authorizing the state of Wyoming to fight for the dual banking system because we find that it is in the best interest of the state for reasons of innovation and all the work that we've been doing to do so. Is this then compelling to a court? It's going to be up to an individual judge. There's literally nothing we can do. We can put 100 shalls in this bill, and won't make any difference if the court doesn't decide we have standing. So it's not about the shalls. It's really just about how can we write this so that a court would be potentially convinced that the state as an actor has an interest and therefore standing in a case in the dual banking system.
Okay, all right, thank you for that clarification. Any questions for the senator? Seeing none, thank you very much. No other elected officials in the room, departments of the state? Thank you very much for being here. Good morning to you. you've got a radio voice, so please proceed.
Thank you, Mr. Chairman. Jeremiah Bishop, State Banking Commissioner and head of the Division of Banking. Our office regulates state chartered banks, among other entities in Wyoming, and we also interact with other state and federal regulators. This is one that, as the good senator said, was worked during the interim. This one I have to kind of walk a tightrope on because I'm pulled to either side of just kind of what it does. On the one hand, this aligns almost exactly with one of my statutory responsibilities to ensure that our state chartered banks remain competitive with nationally chartered banks and to protect the dual banking system. That is in statute, one of my duties. And so this aligns with that. But on the other hand, we also ensure the safety and soundness of our institutions. And so I do have to, I'd say, take a step back from this, because if the state intervenes in a lawsuit against an institution that I regulate, I just can't be involved in it. I'm not saying it's good or it's bad. They might be good reasons for it. Oftentimes there would be. I just have to remain somewhat independent of it. I just make sure that's on the record. I'm not taking a position on this. That's why this is intentionally leaving me out of it. It is pointing this to the Attorney General's office, which is exactly where it should be. So I think it puts me in a decent position. It doesn't put any impact on me that I think would harm my ability to conduct my job or work with these other regulators. In the instance where the state did make a motion to intervene, I did have to call the other regulator that it was directed to and have that conversation. Yes, we can still work together, and they agreed. We can also still do our jobs and let the legal side of things get worked out. So with that, I don't have any other comments, just more if there's any questions more on the dual banking system and how it works. Happy to provide any information on that side of it.
Thank you, Mr. Bishop. Appreciate that explanation. I can certainly see how that would be a tightrope to walk there. Any questions for Mr. Bishop? Seeing none, thank you very much for your testimony. Anyone else in the room that would like to testify on Senate File 135? Mr. Meyer, thank you for being here. Are there any others in the room that plan on providing testimony? The rest are just here to observe. Okay, Mr. Meyer,
Mr.
please
Chairman,
proceed.
members of the committee, Scott Meyer on behalf of the Wyoming Bankers Association. This is an interesting bill, and I think Senator Rothfuss said it right, that it got our attention when they started saying about any state bank. We do have a dual banking system, but in Wyoming, we kind of have a triple banking system in the fact that you have national banks and you have local state charter banks, but those can be divided into those who can lend, like traditional banks, and the speedy banks that are more of a custodian of the assets. So there is a little bit of a difference. This bill got our attention in the fact that, the community, your state community banks didn't bring this up, but the fact that it's been brought up brings to light, I guess, a lot of questions that we have, and maybe some support that your traditional banks could get. And one of those is the Dodd-Frank bill that's out there that has directed the CFPB, or the Consumer Financial Protection Bureau, under 1071 for the banks to start providing a lot of information regarding consumer loans. And it's an onerous bill, it's an onerous section of it. They make it almost impossible to deal with consumer lending, business lending, to deal with it. And so we would dearly love to have somebody go to bat for us. We do think that there's a question when it comes to standing. I'm not sure you can legislate standing, but I understand where Senator Rothfuss is coming from when he says, hey, maybe this gets, I'm not sure if it gets your foot in the door for it's just the camel getting their nose under the tent, but one way or the other, we're having some impact on this. But should this bill become law, I will guarantee you that your Wyoming community banks will probably be down talking to the Attorney General saying, hey, on July 2nd, we need you to start looking at the CFPB and at the impact that this is causing our Wyoming community banks. And assuming that the current administration hasn't already eliminated the CFPB, but you never know how that's gonna go. I think the interesting thing though, as the bringer of the bill brought up and discussed it there, part of this was brought up because of existing lawsuits. I don't know where that would put the Attorney General, because the Wyoming Bankers Association filed a brief in that one taking the opposite side of where the Speedy Banks took. So where does that put in the state of Wyoming as to picking one side or the other? I'm not sure. I'm glad that that's why the language has been changed from shall to may, because that would give the Attorney General a little bit of cover, if you would. But to the extent that the state could go to bat for your Wyoming community banks, I gave you one example, but there's hundreds of others out there that we just seem to fight every day. And it would be great to have that help. I am concerned a little bit about the fiscal note in there, because I know that my counterpart at the Texas Bankers Association has been filing lawsuits at enormous cost. And they've been, representing themselves and the banks that are in Texas, fighting over a lot of these issues that I just brought up. And it is a tremendous amount of cost to them, but also to the state of Texas. So I question, I guess, the idea that the fiscal note is not there. That I think that's a big number. With that, Mr. Chairman, I certainly stand for any questions.
Thank you, Mr. Meyer. Questions for Mr. Meyer? Mr. Meyer, in my short tenure in the legislature, we've talked about Speedy Banks quite a bit. And you have provided a lot of testimony about as this evolves. It seems like there's a lot of things that have to be rounded out and fixed and resolved as these Speedy Banks got up and running. Do you see this as something that is necessary, this bill? Is this something that you support and as necessary, or is it something that we could possibly do without?
Well, Mr. Chairman, all I can tell you, I guess from my perspective, is that, we've never taken a position as good or bad with regards to Speedy Banks. They are their own entity and they do their own thing, and they have their own niche, which is fine. I'm not sure, I guess, whether this bill would actually help, because I think even as the bringer of the bill said, we're not sure about the standing issue. So I don't know that this does, in my opinion, whether it does anything to help either any bank in Wyoming, let alone just the Speedy Banks. But I know, you got to feel for those guys. They've been fighting. Every time they turn around, there's another wall that they have to go through, and I understand that. But at the same time, we understand why there's the fight.
Thank you. Thank you, Mr. Meyer. Seeing no further questions, thank you very much for your testimony.
Thank you.
Once again, any other testimony in the room? With that, we will close public testimony. Members, what's your pleasure? Any motions? Any motions? For lack of a motion, we will not proceed with this bill then. We'll lay it on the table. All right, thank you. So, members, this is the last meeting of our House Minerals Committee. We have met 13 times over the past few weeks, and by my rough calculations, we've spent about 30 hours together. 30 hours, so quite a bit of time with some high visibility and very impactful legislation. For the next few months during the interim, we will be meeting jointly with the Senate. It'll be a joint Minerals Committee. So thank you for your service to not only the Minerals Committee, but for your constituents and the state of Wyoming. Appreciate Vice Chair Tarver sitting in and helping out. And especially we appreciate Mark and Tanner for all that they've done to make this committee successful. Those people behind the curtain pulling the levers in Ozland are very, very appreciated and don't seem to get the recognition that they deserve. So thank you so much. With that, we will close the last time gaveling as a House Mineral Committee.